Okay, it looks like our attendees are starting to trickle in here. In the interest of time, we're going to kick off today's webinar. Good morning and welcome, everyone. Thank you for joining us for today's Fundamentals in Healthcare Law webinar focused on licensing and privileging. This is the 6th of our healthcare series. Many of you have probably attended our past series, and thanks again for joining us today. You can see our upcoming schedule of events. We will be sending out email notifications, and of course, this information is listed on our website. The focus of our next webinar, which is scheduled on Wednesday, March 16th from 8:30 to 9:30 a.m., will be on Medicare Basics. So we hope you join us for that. Again, good morning. My name is Jason Castor. I'm the Chief Business Development Officer for Parsons, Behle, and Latimer, and I'd like to welcome you to today's presentation. Thanks again for taking time out of your busy schedules to be with us this morning. Before I introduce our speakers, I'd like to cover a few quick logistical items. First, today's webinar is being recorded, and you will be provided a link via email to the recording to share with your colleagues and teams that were not able to join us today. Also, this email will include a copy of today's PowerPoint presentation, so you'll have that at your fingertips here within 24 hours. Second, we've allotted time at the end for Q&A. So please use the chat feature to submit your questions throughout this morning's presentation, and we'll do our very best to address your questions at the end. And finally, it's important to note that today's presentation is considered a general source of information and is not intended and will not serve as a substitute for legal counsel on these issues. You should not act upon the information provided without consulting your legal counsel. Okay, with housekeeping items aside, I'd now like to introduce our panel today. First, Lee Radford is a shareholder in our firm's Idaho Falls office and is the chair of our Corporate Securities and Tax Department. Lee counsels his healthcare clients in a wide range of areas, including contracts, insurance, and employment and other business matters. Jameson Rammel is an associate also in our Idaho Falls office. He has experience in handling all aspects of civil litigation, including healthcare law in both state and federal court. So with that, I'm going to now turn the time over and welcome Lee Radford. Lee, thanks for joining us. Jameson, thank you as well for joining us. But Lee, you'll kick off our presentation today, so I'll turn the microphone to you.
Thank you, Jason. We appreciate it. It's great to be here, and these are topics that are very interesting. It's good to try to sort through them and kind of try to understand the structure of what we probably deal with a lot every day in the healthcare world, but sometimes we don't maybe think about how it all gets put together. Our presentation today, I'm going to be talking about kind of the organization of licensed providers, licensed physicians, and how they're organized in our healthcare world in the United States. I'm going to be talking about the different organizations they're part of and how they get regulated. Jameson's going to give some experience on what that means on the ground when there is a disciplinary proceeding or investigation of a licensed provider, and we'll kind of take some of this as applied. So the thing that I think we all have to understand is that physicians and healthcare providers really are subject to a number of layers of different regulation and oversight. Some of these are almost voluntary, some of them are mandatory, but they all end up being fairly compulsory just because of the nature of the system. Of course, a physician or a provider needs to be licensed by a state licensing board. Almost every kind of healthcare provider needs some kind of licensing. Beyond that, there's also specialty boards, the board certifications that physicians can get in their specific areas. Those in some ways seem voluntary, but they're not entirely because of the nature of what's required to be on a medical staff and to treat patients. The other organization that regulates physicians is the hospital medical staff, the medical staff of the hospital that we talk about. And we're seeing more and more regulation through various types of insurance networks, provider organizations, accountable care organizations, the different types of organizations that are attempting to provide value-based services and organize healthcare in a more efficient manner. We're seeing more regulation through those kinds of organizations. Of course, a physician is also subject to oversight by that physician's group or practice, depending on how large that is. There may be some oversight there as well. And of course, in all of this, there's an overlay of Medicare and Medicaid reimbursement, that there is some level of regulation in all of this just by the nature of how Medicare and Medicaid reimburses services and how Medicare and Medicaid expect services to be provided to be reimbursable. So that's another overlay that we won't get into much today, but is kind of weaves its way through all of this. And finally, physicians are subject to the courts. There is medical malpractice litigation when there are injuries that result from mistakes in treatment or diagnosis, and then physicians and providers find themselves hauled into court to be answerable to juries. And so that's another level that is out there on the horizon that we always hope to avoid, but sometimes we have to deal with. So those are the layers we're going to be talking about. So I'm going to break those out now a little bit into the different components and talk a little bit about each of those layers as we go forward here. The first layer, of course, when a physician graduates, finishes medical school and moves forward with their training, they need to get licensed by the state. States are generally the licensing authorities for physicians and a lot of healthcare providers. And so you have licensing boards in every state that provide different licenses for different types of healthcare providers. And it's interesting to see just the variety of different types of healthcare providers that we see just here these are just in Idaho here. We have a board for athletic trainers. We got the chiropractic board. We got the dentistry board. We got a dietitian board. Of course, we have the Idaho Board of Medicine that deals with, licenses both physicians and physicians assistants. We've got a naturopathic board. We've got the Idaho Board of Nursing, which deals with nurse practitioners and nurses and the various types of nurses. We got an occupational therapy board, optometry, pharmacy, physical therapy, podiatry, respiratory therapy, speech and communication, counselors and therapists, and there are others too. I didn't put the complete list. So we have each of these boards that are operating here in the state of Idaho, and usually you're seeing the same in other states as well. So it is, it is very, so each type of provider goes to their board. Jason, could you go to the next slide? Oh, there it is. So the licensing statutes, when you get into the licensing statutes for each one of these types of organizations, you find that they follow a common theme, and this is generally true in all the states and between all these different types of licenses. Usually they'll start with a prohibition on any type of practice without a license. You can't practice medicine without having a license from the Board of Medicine. You can't practice chiropractic without a license from the chiropractic board. So it starts with a prohibition on the practice without a license. It also generally establishes a board of people who usually they're licensed professionals who've already been licensed by the board, and they are the ones who kind of govern the licensing and investigations and govern the activities of the board. Usually you'll find their procedures for the issuance of licenses, what kind of schooling, what kind of testing, what kind of practice requirements are required for each different type of license. And then you get into, there's usually a section of the various grounds for discipline. And I always find this pretty interesting, and it's good to review. Usually it's a long list of the types of things that they are going to regulate and look to that they do not want their licensees to engage in. And those grounds for discipline become important because the statutes usually provide the procedures for investigation and discipline if there's some violation of those grounds for discipline, of those ethical standards. So this is the general structure for each of these licensing boards. Here in Idaho, we've tried to consolidate and have some kind of uniformity between these different boards to make it a little more understandable. But each one is different. Each one gets to be governed by, the nurses are governed by nurses, the doctors are governed by doctors, the chiropractors are governed by chiropractors, and they get to form within this structure how they want to run their licensing and what they're doing. So that's state licensing, and it's important to stay on top of that state licensing. It's going to be critical. Reimbursement and payment in healthcare is going to depend on being continuously licensed. So it's an effort to always stay on top of that. Now there's another level beyond licensing, and this becomes more of a voluntary in nature. As a provider, especially a physician, gets out of medical school and does a residency, that physician can then choose where they specialize, and the specialties are also governed by boards. These are somewhat voluntary boards. They're essentially private organizations of physicians in that specialty, but then and physicians can then decide to become part of that board or that organization. It provides them a specialty that they can then advertise and go to the public as having that kind of specialty. The boards function to promote the practice of that type of scope of practice. They support each other and encourage the development of that practice, but they also are very rigorous in making sure that the people who claim that scope of practice really have the specialty and the experience and the education and the abilities to wear that label of having that kind of specialty. And you're probably familiar with a lot of these. I didn't list all of them. There are a lot of boards of medical specialties here in the United States. And some of them you're probably familiar with. I listed, allergy and immunology, anesthesiology, dermatology, emergency medicine, family medicine, internal medicine. The Board of Internal Medicine has a lot of subcomponents to it: infectious disease, pulmonary, sleep medicine. Then you have specialties like obstetrics, gynecology, ophthalmology, orthopedics, pathology, preventive medicine, psychiatry, radiation oncology, and there are others. And again, the physicians get to choose which ones they want to go with, but you'll see as we go forward here that these specialties become important as the hospital is organized and moves forward. It's important to keep these board certificates in mind. Sometimes we overlook that as we're thinking about physician licensing and physician credentials, because in addition to maintaining the license, the physician has to also keep up that certificate with the physician's certifying board. So depending on the board, that requires some education requirements. It sometimes involves periodic testing requirements. It involves periodic qualification procedures. And the boards will impose those kind of different requirements to make sure that the people carrying that label of their stamp of approval, their certification, really do have the abilities that they expect of their colleagues. The other important point to know about this is they also have their own disciplinary procedures. So if you've got an OBGYN that carries a board certification as an OBGYN, and that OBGYN gets in trouble and does something that makes them subject to discipline, then the certifying boards can go after that physician and impose disciplinary procedures on him or her and go after that discipline just like a state licensing board can. And the loss of that board certificate for a physician will be very detrimental, can destroy a practice just as much as losing a license in many cases. So you have to keep in mind that not only is there a state licensing board, but there are the physician specialty boards that both have to be kept up, and both are separate and both have a lot of requirements. All right, so that's two levels that we talked about. So we talked about the state licensing board, and now we've talked about the board, the specialty boards. Now there's another level that's important that we deal with quite often, but is a separate organization with separate regulatory functions and a separate purpose. And that is the medical staff of a hospital. So the medical staff of a hospital is really a unique relationship, and most people outside of healthcare have no idea really what it means or what it is. The medical staff of a hospital is a situation where hospitals need providers, but those providers are not usually employed by the hospitals. They are independent providers with their independent licensing and certifications that usually have their independent practices and maintain their own billing and revenue streams. On the other hand, the providers need hospitals. Providers need hospitals as a safe place for treatment and care of patients. Providers may have an office or a clinic, but they don't have the advanced surgical care and diagnostic tools and treatment tools that hospitals have. And providers need hospitals in order to provide the treatment that they want to give to the patients. So it's important to understand this is not employment. Like normally in the world, we're thinking about employees or independent contractors. This is neither of those relationships. It's not an employment relationship in most cases. We'll talk about that exception to that. It is essentially what we call in the law a license to use the healthcare facilities of the hospital. So the hospital is allowing the physician to come in and provide treatment and use the hospital's facilities. But in exchange, the physician has to maintain credentials and privileging necessary to make sure that the hospital can trust them to use those facilities. And that's what the medical staff is functions for. So there are exceptions to this, and sometimes it's developed more recently that there are occasions where hospitals actually employ their own physicians and pay physicians a salary especially for certain types of physicians. And if that's the case, we often have to figure out whether a physician is employed or whether they're just a typical member of the medical staff. But if they are employed, you always have to remember that they're subject to two different levels of oversight. One is that they're part of the medical staff, just like every other physician and provider. But the second level is they're also an employee. They're subject to the employment policies, the employment manual, and administrative oversight, just like any other employee would be. So employed physicians are have two levels of regulation by the hospital. But generally, the medical staff of the hospital is going to be governed by certain things. One are the bylaws and the policies of the medical staff and the board that organizes. Another thing is the Medicare conditions of participation, the COPs, that Medicaid in their regulations require these medical staffs to be organized and have certain specifications for them. So you'll find a lot of commonality between medical staffs of different hospitals because a lot of that is required for Medicare and Medicaid reimbursement. And also accrediting organizations that accredit hospitals as compliant with Medicare and Medicaid requirements often have their recommendations and their ways that they recommend that staffs be set up. And so that often governs what the medical staff of the hospital is going to be. So the medical staff bylaws, medical staff will be organized. These are just like separate organizations like the certifying boards or the state licensing board. It needs to have an organization to implement this kind of regulation. And the idea, again, for this regulation is to make sure that the hospital is functioning together, that the hospital providers, all the providers who are there, are working together and are following common standards of practice, have the qualifications to provide safe and effective treatment, and that is kind of turned over to the medical staff, to the doctors themselves. So the bylaws generally provide for some governance. Ultimately, the governing board of the hospital, the owners, the board of the hospital, has to have ultimate responsibility for what happens in the hospital. But they can delegate all of these functions of overseeing the physicians and providers to the medical staff. And so they set up a medical staff organization with the medical staff's board to do that. And with that, there are several functions that you see in the medical staff. One is first credentialing, which is just appointment to the medical staff. So they're in charge of how applying and being appointed to the medical staff. They usually will deal with the other health professionals, the nurse practitioners and physician assistants. The bylaws will provide how they become part of the hospital provision of treatment. And then there will be a section on privileges. What kind of clinical practice will be allowed for different scopes and practices and specialties. And then there'll be the disciplinary portions of the bylaws, that these boards can also impose discipline on their doctors if the doctors are not performing in a competent way or not taking care of patients in the way that's expected of the medical staff. And so there'll be a hearing and appellate review provisions. There's often a code of conduct, and usually there's organization provisions about when there's going to be meetings, who the officers are, who the committees are, and what the departments are. So the medical staff has its own organization. We often talk about credentials and privileges. It's important to understand these are from the medical staff. There's credentialing, which means getting appointed to the medical staff, making sure the physician did have the right education, is appropriately licensed, has the right qualifications. There's privilege. Then there's privileging, which is deciding what scope of practice the physician can do. Most physicians will have admitting privileges to admit a patient to the hospital, but they also need different types of scope of practice or surgical privileges to say which members of medical staff can perform which surgeries. And that's going to be based on their experience, their education, their qualifications, and going back to the board certifications. You're going to need certain board certifications to do certain types of treatment. And so that's important. So that's medical staff under for each hospital or each organization. Now, we've typically seen these in hospitals, but we're seeing them more and more in these integrated networks, in accountable care organizations. Insurance plans are also imposing this type of medical staff as well, because it's the way that they can impose discipline on their group of physicians. We also have a federal law that helps medical staffs be successful in performing this function of making sure that the hospital's treatment is being performed competently and well. And this was a law that was passed in 1986 called the Healthcare Quality Improvement Act. And that Healthcare Quality Improvement Act has two big functions. And you're probably familiar with these, even if you haven't seen it, you don't know the law itself. One is it really helps medical staffs discipline themselves, because before the act, sometimes staffs would try to discipline a physician, and then the physician would go to the courts, go to the federal court, and then sue the hospital and the medical staff and medical staff officers just for trying to do their job of disciplining and keeping a competent staff. The federal law came out and said that as long as the medical staff are making good faith efforts to really improve their practice and improve treatment in the hospital, that they're going to have immunity from civil litigation, and they can't just be dragged into federal court every time that there's an attempt to discipline a physician. And that's helped to limit that kind of litigation and make it so the medical staffs have some freedom to do what's needed to really provide effective care. The other thing that you're probably more familiar with is it provides a national database of competence issues for individual physicians. And you know this is the National Practitioners Data Bank. And that prevents a physician who's been disciplined in one state from moving to another state to avoid disciplinary procedures. So that's an important component of this as well. So for hospitals, this isn't really voluntary. Hospitals have to both report and seek information from the National Practitioner Data Bank. So if there's an adverse action taken against a physician, the hospital has to report it. And when a physician is brought on and given credentials, the hospital has to query the National Practitioner Data Bank to make sure that that physician doesn't have discipline in the past that needs to be completed or remedied somehow. As we said before, the Healthcare Quality Improvement Act gives some limited protection to the medical staffs to do their job. It doesn't protect them against civil rights claims. It doesn't necessarily protect them against injunctions or affirmative directions, but it doesn't, and it also doesn't create a private right of action against them. But basically, it provides a set of standards that if your bylaws meet those standards for what kind of hearings and procedures are given to a disciplined physician, that its courts are going to uphold that and give deference and allow that discipline to stand. It is important. You'll see these definitions of what a professional review activity is, that when medical staff gets disciplined, it has to be within the scope. It's, anytime that you're determining whether or not someone should have privileges, determining what the scope of those privileges are, or when you're changing the scope of those privileges as a medical staff, that's a professional review activity that is going to have the protection of the Healthcare Quality Improvement Act. But like I said, it has to be in good faith. It's got to be, the medical staff has to be acting in the reasonable belief that they were furthering quality health care. There's got to be a reasonable effort to obtain the facts of the matter. There's got to be adequate notice and hearing procedures, and it's got to be in the reasonable belief that the action was warranted. So they have to be acting in good faith. This can't just be some vendetta or trying to exclude an outsider or something like that. It needs to be based on sound medicine and sound treatment. So to wrap up here and to transition to Jameson, I've given layers of these of physician licensing and credentialing because when a physician faces allegations of some kind of improper practice, we'll often see a kind of a cascade of disciplinary actions at all these levels, and they kind of copy each other. And so a physician needs to be very mindful of that as if they start slipping into this kind of problem, or if they have some accusations against them, that if you deal with one, once it starts snowballing, it can really snowball out of control. So it's important to deal with it quickly, find a remedy, take care of the problem, and move forward before you have the problem at multiple levels. Because if a state licensing board imposes some discipline on a physician, then you're going to see that the certifying boards are going to see that when it gets listed on the National Practitioner Database. The specialty boards are going to follow up and do their own investigation of the same conduct, maybe the same incident. You might see the medical staff follow up on that. You're going to see insurance networks follow up on it and copy it as well. And it can go in the opposite directions too. If the medical staff pursues something, you might see the state licensing board then look at that and copy it and do their own discipline, and and so on. Any of these can come first, but you just always have to remember that it's important for the physicians to usually take care of it early and address the problem hands-on and directly. Usually, as I think Jameson will say, The worst thing is to try to deny one, then another one's going to pop up, and they're going to keep springing up if you don't take care of it very promptly. The system has these layers of regulation and discipline, and they're designed to give us a very healthcare, and the practice of medicine is highly regulated. There's just no avoiding that. And because it is such a sensitive area where it's necessary to demand the highest standards of due care and competence. And so you see these multiple layers and different groupings to make sure that that happens. So with that, I'll turn it over to Jameson.
Thanks, Lee. So for a few minutes, I just want to talk about investigations from licensing boards. I think given our limited time, that's a good place to focus on. And it'll illustrate some of these principles that I think are important when you're responding to any type of complaint or allegation. As you can imagine, this is a stressful process for healthcare professionals. They feel like they're being critiqued. They can feel like their livelihood and careers are on the line. And so there's a lot of emotion and stress that can be involved, and it's exacerbated by the length that it takes to finish this process. If a complaint is received and a formal investigation is opened, it can take months and months. The Board of Medicine only meets quarterly on these matters. Before they even get it, the investigation has to occur, and a committee on professional discipline has to meet. And so there's all these steps in the process that can really slow it down and really ramp up the stress for anyone being investigated. So Idaho law provides some specific grounds and guidelines for professional discipline. In terms of the Board of Medicine, Idaho Code Section 54-1806 and 1806A grant the Board of Medicine broad investigation powers. And so sometimes a healthcare professional may feel like an investigation is just diving way too deep and being blown way out of proportion. And how could the Board of Medicine even have the discretion or an investigator to do this? But it's important to recognize and understand that the Idaho legislature has granted broad investigation powers to the Board of Medicine, and that they can create these committees on professional discipline and do things such as, in fact, Section 54-1806 gives the board power to, in any investigation, to administer oaths, take depositions of witnesses with or without the state, issue subpoenas. And so there's all of these broad investigation powers that they have. But before the Board of Medicine is ever going to impose discipline, evidence has to be obtained, verified, and presented to a committee on professional discipline. The power to create this committee is also set forth in Section 54-1806A of the Idaho Code. These committees are supposed to be made up of, or the committee is made up of 4 physicians who are licensed in the state of Idaho and 1 non-physician. And we'll talk a little bit more about where they fall in the process and what their role is. So the first stage in any process is just the complaint or the issue that triggers the investigation. If it does come in the form of a complaint, the person filing the complaint has to sign the complaint. These cannot be anonymous in this process. The Board of Medicine then acknowledges receipt of the complaint, initiates an initial review, and then opens a case file. At that point, a preliminary evaluation is going to happen by the Board of Medicine staff. Some of these complaints may seem more frivolous, some of them may seem more serious. And based on that initial review, they're going to decide what type of investigation is going to occur. The scope of the investigation, at least an initial determination is going to be made about what that may look like, and an investigator is assigned to the case. If they feel like they need more information, they may reach out to the complainant to obtain that before they give notice to the healthcare professional who is involved in the complaint. At that point, after an investigator has been assigned, the healthcare professional receives notification that a complaint has been received and that an investigation is going to be conducted. Generally, in this notification letter, a lot of times the complaint will be included, or details of the complaint will be included. the specific nature of the allegation will be included, and the healthcare professional will be asked to provide a written personal response within 30 days. Usually, and it depends on the nature of the allegation, but supporting documents are going to be requested, relevant documents. Depending on the type of allegation, this could include medical records, and the Board of Medicine does have the ability to request the production of patient medical records. So this stage, responding to the complaint, is where I'd like to spend a few minutes, because I think that is the most important stage for us. It's where we have some control, some ability to decide how we want to respond and what we want our tone to be. And it can make a big difference the way that you respond to these types of complaints. So I've just noted a few lessons that I've learned responding to various complaints from the Board of Medicine and other regulatory agencies. So I think having a positive relationship with the investigator is important. I think at the outset, that's something to keep in mind, because unfortunately for them, they almost become the face of this. You know, the healthcare professional can feel like they're the bad guy, they're out to get them, that they have some type of axe to grind. And in my experience, that's not the case. These investigators are just trying to do their job. They're just trying to help, and all they're doing is gathering information. I have a little bit of, well, I don't want to say personal experience with this exactly, but before I became a lawyer, I worked for a university. And one of my roles there was to meet with students who had been suspended shortly after they found out that they were being asked to leave the university. So as you can imagine, they were upset, they were angry, confused. And I was not involved in the decisions to suspend them. I generally had no idea why they were being suspended. My job was to meet with them and provide helpful information about leaving the university, what was going to happen with their current course load, what should they do about an apartment lease, and then what would it look like for them to come back to the university, maybe some steps to take. But again, kind of similar to this, I became the face of their suspension, because I was meeting with them in the middle of a very stressful and emotionally charged situation. And as you can imagine, sometimes those meetings didn't go well. Despite my best efforts to be, nice and charming, they didn't care. I was kind of a lightning rod for a lot of their frustrations. And so from that, I've learned that it's important to realize everyone's role. And some people are just middlemen, some people are just gathering information, and they're not responsible for whatever you perceive as the negative thing that's happening. And I think that's an important takeaway here, is that there's a board investigator and they're just doing their job. And so they're not out to get you, but if you are negative towards the investigator, if you're difficult to work with, that will hurt your case and that will hurt your cause, because that's going to come out later. So I think it's important to have a positive relationship. And if you don't have a prior relationship with the investigator, if you haven't worked with them before, I think it's good to reach out early on and introduce yourself and establish a good working relationship moving forward. That sets the tone for this entire process. It shows that you want to comply and be cooperative. It shows that you are open to correction. And I think that's the right tone to set. As I mentioned, generally they'll give about a month, a few weeks, 30 days to file your response. But in my experience, if you request additional time, they're going to grant that, at least some initial reasonable requests for additional time. Maybe you need an extra month or two, maybe they've requested a bunch of documents, but reasonable requests will generally be granted. And even after you file your response and provide documentation, don't be surprised if the investigator decides they need more information and documentation. It doesn't necessarily mean it's going poorly for you or that they don't believe what you're saying, but they're just trying to compile the information they think that the Committee on Professional Discipline and ultimately the board needs to make a decision. So as Lee mentioned, and as I've mentioned, tone does matter here. And in our experience, and in my experience, I think the Committee on Professional Discipline and the Board of Medicine look more favorably on professionals who are willing to own up to their mistakes, take responsibility, and demonstrate a desire to be better. We always want to see people who want to improve. I think in any context, that is more appealing to people, is if someone is humble and they're willing to be better and acknowledge their mistakes. And that's especially true in this type of investigation. And so the tone here can make a huge difference. And so generally in these written personal responses, we conduct our own, I guess you could say, mini investigation if we've been hired to assist the healthcare professional respond. We're going to look at what they did. We're going to look at what documents they're going to provide and that are relevant. And we're going to decide if there are mistakes that were made and if the board's investigation and complaint have merit. And if they do, and if there were honest mistakes that were made, we want to acknowledge those and show that, yes, we recognize this was a simple mistake, and we're committed to doing better. On the Idaho Board of Medicine's website, it gives this information. It says, usually formal disciplinary action results when there is a provable pattern of unfavorable practice. In isolated areas of practice, corrective efforts such as education, treatment mentors, or voluntary or involuntary limitations of practice may be initiated. These actions may or may not be public information. So I think that's an important takeaway here, is that formal discipline, the more serious discipline, is only going to be applied if there's a pattern, a provable pattern of misconduct. Everybody makes mistakes. Everybody has moments where they could have done better. And unfortunately, sometimes that may trigger some type of investigation. But if you can show this was a mistake, I'm committed to being better, you increase your chances of avoiding more serious formal discipline. And it may result in some type of less serious informal discipline or no discipline at all. On that note, the second bullet point here, it may be worthwhile to implement some corrective measures before the committee even meets. This is just a way to show that you're committed to improving, that you recognize that there may be some areas where you could be better. This may take the form of taking some continuing education credits or instigating some type of limitation on a practice. That's not necessary all of the time, but depending on the facts of the case, that may be worthwhile to show the committee and the board at the outset, I recognize there are some mistakes and I'm already taking action to correct it. We have had experience where an outside expert is retained by the board to look into the case and provide an opinion and perhaps review medical records. It may be worthwhile at that point to consider retaining an expert of your own, just so that there can be a couple of opinions there. You know the old saying, sometimes when you're a hammer, everything looks like a nail. And so if somebody has been hired to look at a case, they may have a tendency to look at it less favorably and more punitive than perhaps an expert that you've retained. That can be more expensive, but it is something to at least keep in mind depending on the seriousness of these allegations. So after you have prepared your formal written response and submitted to the investigator, there may be some requests for additional information, like I've said, but at some point it's going to be set. Your response is going to be done. They'll have the records they think they need, and it's going to be presented, reviewed by staff, and then presented to the Committee on Professional Discipline. My understanding and past experiences is that the Committee on Discipline meets about quarterly, and they'll consider your case. The investigator is involved in that process in terms of discussing the case with them, and then they decide on a recommendation to make to the Board of Medicine. As I mentioned, the Board of Medicine is the final say on these matters. So even though the committee makes that recommendation, the board may deviate from that, or they may follow it. And that brings us to stage 5. The board considers the recommendation from the committee and they make a decision. So there's some different types of actions that the Board of Medicine may decide to take. I have those listed there 1 through 4. They can close the case with no further action if they don't feel like any action is warranted, or that there were any violations of the Medical Practice Act or the rules of the Board of Medicine. If they feel like they need more information, they can request it. That's frustrating and problematic because by the time you get to this stage, it's been months and months already. And so because they don't meet that often, because it may have to go back to the Committee on Professional Discipline, who only meets quarterly, if they need more information, that can be frustrating because it just prolongs this really stressful process, but that is an option. But generally, the investigators and the committee have a sense of what the board is going to need and what they're going to want, and they'll get that information before it's ever presented to the committee and the board. Another option, and we see this quite commonly, is there will be some type of informal action, perhaps a letter of concern that is not made public. There's nothing public, no public discipline at all, but they just express concern to the healthcare professional about, perhaps a one-off a mistake or violation and ask them to be more careful moving forward. There may be other requirements informally, such as taking, like I said, continuing education classes. But whatever it is, they can close the case with only taking informal action, or they can initiate the formal disciplinary process. So whatever decision they make, it usually takes the board about 1 to 2 weeks to send you notice of their decision. They'll send a written letter laying out what they've decided. But in my experience, the investigator involved has knowledge of what they've decided shortly after the meeting happens, and they're generally willing to share that with you. So after the meeting happens, you can give a call to the investigator and they can share that with you. And that's just another reason why I think it's good to have this good working relationship with any investigator assigned to the case, because they can provide some helpful information. So if the board decides to go with formal action, obviously at this point it's more serious. It could be more public, but it doesn't necessarily have to be a disaster or reason to panic. These can be resolved by stipulation. You stipulate to make certain changes or do whatever the board thinks you may need to do to improve your practice or correct the mistake. Or they can go to a formal administrative hearing, which is similar to a trial, and that can take several days. As Lee mentioned, there are still rights, including rights to due process and notice, and any decision from the board can be appealed to district courts and ultimately to the Idaho Supreme Court. So I guess just my final thought is, when it comes to any type of investigation, when it comes to any type of disciplinary proceeding, I think it's important to not panic. I think it's important to realize that it's just a preliminary investigation, that you have an opportunity and some rights to notice and to respond, and that there have been many people that came before who have had this stressful experience and they come out the other side better for it, and their practices or whatever they're doing are better for it because they've learned some important lessons. And by taking the right tone with the board and the investigators, it can make a huge difference in the ultimate outcome.
Thank you
Thanks,
very
James.
much, Jameson, and Lee, thank you as well. Before I turn the time back over to Lee, I would encourage all of our participants to submit any questions that you may have. We'd be happy to address those before the conclusion of today's presentation. Lee, any final thoughts that you may have, or a summary of today's discussion and takeaways from the presentation?
Yeah, I just wanted to follow up with what Jameson's saying, echo everything he says. I think it's important to understand with these physician and provider discipline procedures that they're, it's different than if someone files a complaint against you in a court. And your approach to it has to be different. You have to realize these are professional boards, whether it's the medical staff or the state licensing board or the certifying board. These are boards of your colleagues who have been in the same trenches with you and have done the same kinds of things. Because of that, and they've set up their investigations, and they know what they're doing. It's usually not trying to get a judge or a jury who knows nothing about the case to understand it. For that's one reason why it's usually not going to be very productive to just go in and try to deny and fight and completely advocate for the opposite extreme. It's, you have to understand the context. Usually if it goes into a formal action, like Jameson said at the end, the physician is going to lose because it's already been reviewed by colleagues and professional investigators with experience in the area, and the odds are stacked against you. Another reason why it's very difficult to win these without the approaches that Jameson talks about is because of that cascade of discipline that I talked about earlier, which is that if you start fighting and you get crosswise with your state licensing board and you are going to go to a formal procedure and there's going to be some kind of formal hearing, by that point, the certifying boards, the medical staff, everyone else has copied it and is looking into it, and the provider's career's in deep danger from the other avenues as well. So there's a variety of reasons why we say get on top of it, get to the heart of the matter, address it, try to find ways to improve and move on rather than approach it like a legal case that you're going to just deny things. So I think Jameson's advice is very helpful.
Great, thank you very much, Lee. Great summary, great takeaway. It doesn't appear that we have any questions, so I'd like to extend our thoughts, or our thanks rather, to all of our participants for joining us for today's presentation. Lee and Jameson, I'd like to thank both of you for preparing today's presentation and providing your insights on this important topic. To all of you, just by way of reminder, you will receive a copy of today's PowerPoint presentation. We will also provide you with a copy, or rather a link of recording to today's presentation. And then the last thing to remember is our next webinar is scheduled for Wednesday, March 16th from 8:30 to 9:30. And this presentation or this webinar will focus on Medicare basics. You will also receive an invitation to this event in the coming days. With that, thanks to all of you again for joining us today. We appreciate your support of our Fundamentals in Healthcare Law webinar series. Lee, Jameson, thanks again for your time.
Thanks, Jason.